important as we build out that we are compliant, especially in Web3, because these are new laws that we're learning and creating, especially if you are making a DAO. So with that, I'm super excited to welcome Alex and Simon to the stage to talk to us about compliance in Web3 law, especially in the area of DAOs. Let's give them a warm welcome.
How you guys doing? Doing good? Everybody full? Everybody ate well? That's good. That's good.
I'm sure you're all looking forward to a discussion about regulation.
Yeah. We're here to try to make the law sexy. So, that's kind of how the intention that we came here with. But yeah, generally, let's do a little bit of an intro, right? My name is Alex. Pleasure to meet you guys. I've been an attorney for about 11 years now. I've been practicing in the US for the past 6. I've been dealing with Web3 and DAO projects and dApps for about 4 or 5 years, living in Miami. There's a bunch of different folks who need assistance. And at different stages of the different cycles of the bull runs, right, you can kind of see the maturity of the projects developing. Back in 2020, it used to be people coming through with a roadmap and a plan to make some t-shirts. And they were the people who had like $100 million market cap and no LLC. So those were some of the instances of me getting familiar with Web3 at first. And now the industry is thankfully at a much better place, and there's a lot of different structures and a lot of different systems and ways to protect yourself in the Web3 world in the same way that we do in Web2. So this is kind of what we're going to be talking about today.
Thanks, Alex. And my name's Simon Sorockyj. I'm an Australian lawyer, and you're probably wondering why an Australian lawyer is coming to talk to US companies and US people about compliance. But after Alex goes through and talks a little bit about the available structures in the US and how it can be structured to make sure that you're completely compliant, there's actually a way specific and fit for purpose for Web3 companies to actually create a regulated structure offshore in places such as Australia, not just Australia, but in other places, which actually regulates your DAO or your Web3 company globally. What that means is you don't have to be registered in the US, registered in Australia, registered in the UK, registered everywhere else. You do when it's a security, right? Or you remain unregulated, and we know the perils of doing that for long periods of time. So what I'm here to talk about is a solution for the Web3 industry specifically that can actually avail yourselves of the world's population for adoption into your Web3 solution with one regulatory regime in one jurisdiction.
Right on.
I'll pass back to Alex to start with the US-centric situation.
For sure. So generally in the US, and truth be told, there's a lot of different founders in the US as well who are thinking of taking their business offshore to some, to one extent or another. The thing here is that should be a structured and thought through and a conscious process, right? It shouldn't be just, oh, I'm gonna open my company in Panama, so SEC won't touch me, right? Oh, the tax people won't gonna come and knocking on my door when I don't report all my taxes, right? So you can't necessarily look at this with an approach of trying to avoid something, right? You need to make sure that you are finding a jurisdiction and you are finding a structure that actually works, that actually is compliant in accordance with the jurisdiction that you are choosing, and that your decision to move offshore or structure a company in a way where you have both inshore and offshore presence doesn't equate trying to avoid something, right? It's more about trying to structure it in a more efficient way. And there's nothing wrong with that, right? Apples and Nikes of the world have been in Belize and Costa Rica's for years and years for the reasons that we all know. There's better taxation, there's easier regulations to comply with. So when it comes to the US companies, some of the things that we've been doing at ChaseLawyers for some of our clients is establishing a structure of both inshore and offshore presence, where the founders have the benefit of a Delaware C Corp, our standard basic thing that protects us from liability. And this is kind of the main 2 points that I wanted to touch on. It's liability and legitimization. We need to make sure that we're protected from liability. That's why we set all those legal structures in place, that in case there is a lawsuit, in case there is any type of claim or issue, your personal assets are not affected. Your other businesses are not affected. And the idea here is corporations and limited liability companies, they provide that protection if they're run properly, and if you make sure to comply with the rules and laws that you have to follow. So once you set up a corporation in onshore, right, in Delaware, which is the basic format how people like to set up startups generally, because investors are very familiar with that jurisdiction. You want to put together an additional company that would be managing the actual protocol, right? And for that, there's a couple of different jurisdictions. There's a foundation structure in Panama, Switzerland, and Cayman Islands, and I think Luxembourg as well. There's some jurisdictions that offer an LLC structure, whether it be for-profit or non-profit LLC. Marshall Islands is one of those. So our goal as attorneys is to go to the jurisdictions that the clients think could be a good potential fit for them, figure out the specific laws that apply, and figure out how do we do that to make sure that we keep within the boundaries of those laws. So in the instance with our general structures, how we do it is we have the holding company in Delaware that owns all the IP, where all of the fiat investments go on the basis of standard safe agreements that were created by Y Combinator years and years ago. And then there is an IP assignment to an offshore entity that is managing the protocol and that is governed by the laws that are much more favorable to blockchain-based companies, such as Marshall Islands DAO law. They implemented one in 2022, and they have really specified the parameters of how a DAO can exist and a DAO LLC can exist, which allows for an easier regulatory regime, and then at the same time that safety to the investors of knowing that, well, we're not here investing into a gray market company, right? We're not just going to a Panama offshore entity that is a shell company. We're investing in a Delaware corporation that owns the IP, that licenses that IP to another company to manage the protocol, and then the management of the protocol is where the distribution of funds actually occurs, right? When we're talking about DAOs, that usually means a certain distribution of assets, treasury management, and things of that nature. So if you are planning on setting up a structure, whether it be fully inshore, fully offshore, however you want to go about it, you need to make sure that it makes sense. You need to make sure that it's thought through. It's not just setting up something and then hoping the SEC and the IRS will not get you. You just want to make sure that you're doing it within the parameters of the laws of both the country where you're in, international laws, and the jurisdiction that you want to kind of go to. So I'll leave that as a kind of like small intro to what Simon's going to talk about.
And just like, and backing up what Alex said, what governments are looking for, so what the SEC is looking for and what, obviously the IRS here, but tax departments around the world are looking for, is they want transparency, right? So they don't want to stop the Web3 industry from developing, but what they don't want is they don't want money flows happening that are in an unregulated structure that they don't know where it's going or how it's going to be dealt with, right? So at the end of the day, there has to be a regulated structure to allow the mass adoption of Web3 technologies globally, right? So Alex has gone through a couple of options here available for US companies. Another option which you would not be aware of is, I don't know if anyone here is familiar with cooperative law, but cooperative law can be many things to many people, but cooperatives forget technology for 1 second, cooperatives in their actual, in their real sense were the first DAO, right? It's actually a membership organisation coming together under a common purpose to transact in a certain way under a common set of protocols or rules. Now, I don't know about you, but that's pretty much like defining what a Web3 solution is doing in a digital sense, right, on a peer-to-peer basis through technology. The difference with the Web3 industry is cooperatives were traditionally localized or geographically based between a group of people in a particular area, whether it be farming or any other sort of enterprise. But with technology now, we have global communities, right? They're not just localized communities. So why can't we have a concept of digital cooperatives to regulate the industry? What's the beauty of a digital cooperative? In a digital cooperative, as long as everyone who is participating in there is a member, and you define what memberships are and what active participation in the co-op is, provided they are members, they effectively are outside the auspices of securities law, right? So you can actually issue memberships, you can issue what's called a unit in a cooperative, which acts like a security for fundraising, for distributions, for DeFi purposes, and it is regulated by the consumer regulator, but it is not a security. Right? So effectively what you're creating is a for-profit vehicle. It's not a not-for-profit vehicle. It can be a not-for-profit vehicle, but in this particular instance, what I'm talking about is a for-profit cooperative that manages your protocol, and it's a regulated, registered cooperative. Now, my background has been in formulating 12 of these in Australia, right? So these are tried and tested, and our regulator, the Australian Securities and Investment Commission, which is the SEC in Australia, has effectively looked at this and said, provided you operate within the laws of the cooperative, they don't have jurisdiction, and you can distribute in accordance with the rules of your cooperative, and it is a regulated structure. Going back to what I said at the beginning, the SEC or ASIC don't mind if it's regulated because it's transparent, it's taxable, like AML KYC compliant. They know what's going on, right? So we're adopting a 250-year-old legal structure that had nothing to do with technology and simply adapting it for the Web3 community. The beauty of this is, because you are not ever dealing in securities and you're dealing in a unit in a co-op, it doesn't invoke the securities laws of the countries from where you have members or participants, right? So if you have participants in your software solution, Web3 solution from 50 different countries, technically, if it's a security, you have to examine all 50 countries' securities laws to make sure that you're compliant, because the jurisdiction that applies is the jurisdiction where the investor or the owner of that particular security comes from. That is not the case with a cooperative, right? Cooperative membership can be from anywhere. It's only the jurisdiction in which you register your cooperative, which is the jurisdiction that you need to comply with, right? So for example, an American company could develop a Web3 solution, license the IP to an Australian-based cooperative, sign up their community to a membership, develop the membership rules and the protocols. All of those protocols and membership rules can be put in smart contracts. Everything can be done digitally. But what you have is an underpinning legal right, a piece of paper that actually says that it's a real unit. It's a real legal right. It actually has a basis at law. So all of a sudden, you're taking a potentially esoteric DAO concept and a potentially a securitization issue into a completely new legal regime, which is compliant, which does all the things that you need it to do, right? And to establish a cooperative, I'm talking specifically about Australia now, but it will be similar in most jurisdictions, takes about 3 to 6 months, and it might cost you about $50,000, right? As opposed to potentially going through the securitization route and opening up offshore companies and doing other things, which can be obviously a lot more expensive and a lot more complicated. And it doesn't necessarily solve the issue about the domicility of the actual member and the user, because that invokes other countries' laws. So what I want to do today is just to, I suppose, open people's eyes and share the fact that there is another legal structure in there which actually is a DAO in its own right, but it's a legalized DAO, which now with the addition of Web3 technology allows global communities, right, to be regulated and actually use this as their regulatory framework.
Yeah, it's one of those things where you come back to those original parameters of liability and legitimacy, and this is where we touch upon the legitimacy of it, right? You want to make sure that your business is legitimate despite the technology behind this, despite the fact that it's a Web3 business or it's an NFT collection, it's a DAO. You want to make sure that it's legitimate within the parameters of the people who you want to invest into the business. Whether it be the investors, whether it be the consumers who are your best investors, you want to make sure that A, you are protected in case something happens, and that they are protected and also feel safe and confident in the structures that you're putting in front of them. Because how the fundraising process goes and how any type of sale of assets happen is, at first there's going to be a pitch, and then there's going to be an interest exchange, but then it's going to come to lawyers. And then we are in the due diligence process, and that's where we start finding out that, oh, you probably should have signed some additional documents with some of your contractors. Oh, you probably should have put together some bylaws and maybe had a company that protects your interest and a separate bank account, which would be nice, right? So all of this is to say that no matter what stage you are at, whether you are at an idea stage, whether you are at an MVP stage post-revenue, whether you've already found the utility for your token and found the purpose and the governance rules for your DAO, there is probably a good time, no matter where you are, to go and speak to a lawyer and just make sure that you're doing things properly. So our goal here is just to do a little bit of an educational kind of output to make sure that if you are facing any of the issues, and generally that comes about when you are either collecting money from somebody or paying money to somebody, right? Mm-hmm. The moment you start doing that, you want to start looking at the law and making sure that what you're doing is within the parameters of your specific jurisdiction, as well as kind of the general consensus of what other people are doing, right? That's also an important kind of consideration when you are looking around and seeing what have the successful projects that have started with a ICO, right, and now they're Series B, right? How did they go from being a community-based, Discord-based project into now raising funds from hedge funds and venture capitalists, right? So, and that is where you need to make sure that you have proper structures in place.
And not only that, Alex, I think one of the barriers, obviously, for Web3 industry expansion is adoption, right? And so the safer people feel to be engaging with the solutions that are out there, and they know that there's legal rights attaching to it, and they know that there's protection out there, the quicker the engagement with the communities can happen, right? So everyone sort of looks at regulation as a barrier, and yeah, it can be, but regulation can actually be a factor to unleash communities and actually unleash the business because people feel safe. So it's not always a stick, the regulator, it's actually potentially a carrot as well, where if people can trust in the fact that the organisation's been set up properly and it's running under regulated structure, then people feel safe to transact with it and to engage with it.
Yeah, it's like when you look at the earlier projects that were, popping up on Twitters and different, Reddit threads, and that were actually raising money from their consumers and had those, $100 and $300 million market caps. You can see how at an earlier stages there was always that element of like, oh, we are Web3, we're decentralized, we're all going to be anonymous, right? If you bring somebody an anonymous pitch deck today, and try asking for 7 digits in funds, they're going to get laughed out of the room. Like, what are we doing? So the industry is becoming more legitimate, more mature. It's getting finance, it's getting experience, it's getting competence in, right? As we can see by this wonderful event, right? How many people from different industries have gathered here today to bring this thing up, right? To make sure that we all move forward. So while you're at it, just make sure that you are doing things properly and setting yourself up for success. As I always tell my clients, your lawyer is not necessarily going to be the one who's going to make you a ton of money, but he might be the one who helps you save it when you make it. So make sure that you are thinking about those potential worst-case scenarios in advance so you don't have to come to us or somebody else when the proverbial stuff hits the fan, so to say. So.
Well, I have a talk later where I'll go into a bit more detail around the structure of the cooperative, but I thought it was good today just to see that there are obviously avenues in the United States for United States companies, but there are also global alternatives out there. And when we're talking about Web3, which is a global expansion, it's a global technology, we're not talking about localized laws and localized communities. I think it's important to understand that there are structures out there that are available, right, that can actually embrace the industry rather than sort of repel it.
Yeah, it's about being a digital nomad. Right, and actually, if you Google that, there's a couple of different companies that already help you do that. If you are a wealthy individual, if you have a lot of funds in crypto, they look at what would be the best jurisdiction for you to find, and be your home. And it's, a similar approach in that sense, but you it's a little bit backwards. You got to make sure that you start thinking about it as you're starting out. But what we wanted to do here is that we didn't want to necessarily, to bore you down with all the regulations and provisions and sections. So if you guys have any questions, if you guys have any specific, oh, I'm doing this, and how, some input in regards to what it is that you guys are doing, how we can help you in this particular moment of time, and maybe provide some guidance, we'd be happy to field some questions. What do you got? Got one.
So, excuse me, there's a lot to unpack there, obviously. How about with meme coins? Like, just, let's say you wanted to put out a funny meme coin just for the lulz, right? Now, I know sometimes they're collectibles at this point. Where would you go to the Marshall Islands and spend 15 to 20 grand? Would you do the global, jurisdiction with co-op, or how would you, and what is the budget to do the global co-op? I missed that information.
Well, so I'll start here briefly. So the question here becomes is what it is that you're planning on doing, right? If you're planning on releasing the coin for the sake of releasing the coin, right, the question starts piling up after, right? Oh, you've done it, right? Nothing happened, nobody adopted it. What do? Nothing. Because you don't have any money. There's no claims, there's no customers, there's no issue, right? However, if you do actually get some success, and now you see that, oh, your ICO launch and the corporate launch that you did out of your house that never had any registration or regulation under it, and you don't have a company set up, right? If that is the case, and now you have actually the funds to protect, you actually now have something that is worthy, then that would be a good time for you to start thinking about legal and making sure that you're protected and making sure that you're giving your project as much of a runway as possible, as long of a lifespan as possible, because if you don't do that, it's just going to be, a short, long-lived, short thing. that doesn't necessarily go anywhere. And if you do a rug pull, wonderful, right? Good for you. Run away, right? Like that's, you got one out, right? But if you don't end up being one of those folks, then probably you need to make sure that you're ready for the next steps and conversations with serious investors and customers and things of that nature. We're talking about the cost. The Marshall Islands element is about, I think, $10,000 total, but there's like a recurring fees for the maintenance. Generally, I would say the setup of a specific structure, it should be based on your existing budgeting, definitely, right? And this should be a thing that you budget for. Whether you're planning on raising your funds from your consumers, whether you're planning on raising your funds from your investors, whether you're planning on raising them from your friends and family, you need to make sure that you have a certain bucket for marketing. You need to make sure that you have a bucket for product, and the same thing goes to legal and finance. And then specifics, you might not need a Marshall Islands company, right? It just depends on what it is exactly that you're doing, whether you are, taking in any profits, and a lot of different parameters. Yeah.
And that's where I was going to go with it. It all depends on the nature of the coin itself and the rights attaching to it, right? So and obviously all the things that Alex said about protecting, the assets and the companies and the monies and the risk and liability. Yeah, there are structures that need to be set up for that reason. But if we're looking at whether or not a meme coin could be a security or not a security, people would say up front, well, it doesn't look like it's a security, right? But if it's going up in value and can be traded and it's put on an exchange, it might turn into a security. So you've always got to be careful about what happens to the coin, right? Not just what it was originally produced for, right? So under a strict interpretation of the Howey test, right? They could look at that and go, well, if it's being traded and it's going up in value, then at its basic level, it is a security and it should have been under securities law. So that's when I would say you'd look at the cooperative model, because the beauty of a capital cooperative unit or a unit that you issue in a cooperative is that you define the terms of the CCU. It's a bit like a class of share. So you can actually define the rights and define what the economic distribution benefits or what the rights are packaged into that coin as part of the legal right or the legal unit that's created. So an advantage of doing that would be actually capturing the legal rights as part of that unit up front. So it will offer you more protection.
It's the same thing that the guys who were speaking about marketing beforehand were talking about. There's no one size fits all, right? It's make sure that you have somebody who's involved and familiar with your specific coin, your specific DAO, your specific collection, to make sure that they can tailor the solution towards your business, not just give you something off the shelf. So. But yeah, if you guys have any more questions, happy to field. But I think other than that, we're good to go.
There's a couple.
What you got? I can't see it.
Oh, the lights are blinding us, so we can't see the questions.
I have a question about real-world assets. So, like, as we see more and more real-world assets becoming tokenized around the world, and we have different jurisdictions responsible for the laws, how is that going to relate to being, like, someone in another country owning a real-world asset in a different country, and where do you see, like, the laws and stuff going with stuff like that?
You want to take that one?
You go.
So the real assets, this is the element where the variety of different kind of like legal areas that this particular question covers, that makes it one of those where I hated when my professors used to tell me it depends, but now I have to give it one of those, it depends. Because there's a real estate element if we're talking about real estate purchasing, right? And there's a certain level of additional verification and additional certification that those deals need to go through in order for them to be accepted by the government. Then if we're talking about something, a little bit, more tangible or more fungible, right? This is where we are talking about, it being considerably, less restricted. But then at the same time, you need to make sure that what is tokenization, right? Is it just you're giving somebody assets, they're taking them in and they're creating a coin for you to represent those assets? Then, there are companies doing that in the US and abroad, and there's a bunch of those, right? Then the contract between yourself and that company is going to govern a lot of those relationships, but then those companies need to make sure that they comply with the respective laws. And generally, there's no issue with owning property or opening companies in another country. Like U.S. have been used as an offshore, territory for years and years because it's so easy to just go online and register a Delaware LLC or Florida LLC or whatever else. You don't need to be in the U.S. to do it. And same applies to international transactions. As long as you follow certain rules when it comes to KYC and AML, anti-money laundering, As long as you're staying within those parameters, the same rules and the same laws that have applied to things for ions are going to continue being applicable just because the law moves so much slower than the tech does. So it's kind of like we're going to have to wait and see in regards to a lot of those. That's exactly what's happening with SEC right now, right? And it's catching up on the things that are like, oh, it's making decisions based on the things that happened in 2019 now. So.
And the only thing I'd add to that is that obviously with real world assets, if it's a fractionalized ownership type model that we're talking about, something like the co-op would be very, very suitable for that because you've actually got members that can own fractionalized parts of the entire asset that might be owned by the cooperative. So a model like that might work. So it depends on the asset and what the token or the coin is actually representing as a fractionalized piece of that, or whether, as you said, what the rights are attaching to that in terms of returns or anything like that. But yeah, there's definitely. I would still encourage, because I'm a massive proponent for the cooperative, that because if you're going cross jurisdictionally, the cooperative is a vehicle that allows you to do that from one solid jurisdiction, not multiple jurisdictions. So you won't necessarily have to invoke multiple countries' laws. I have to say, but obviously with something like real estate, if you've got real estate in different countries, it'll invoke real estate laws. So it's not about the securities laws, it will be about the real estate laws in that particular jurisdiction.
Hope that clears it up. But yeah, guys, thank you so much for your time. That's going to be it for us. Make sure to stay legal, compliant, and all that good stuff.